constitutional. Now, in 1986, as recent as 1986, the Supreme Court upheld a Texas law saying, yeah, you can criminalize sexual behavior between people of the same gender. Okay, and again, these were sodomy laws. And again, it just so happened the Bowers versus Hardwick case, it was like an accidental thing. Police officers were actually at a place where they weren't supposed to be. They had the wrong place, but lo and behold, this is the activity they found. And just not even 20 years later, 17 years later, frankly, they changed their mind. Okay, they said, you know what, that's wrong. Okay, you can't criminalize sexual behavior between two people of the same gender. Again, it really becomes a question as to whether it's appropriate to have law enforcement monitoring that kind of behavior when that's the only kind of behavior, right? So, in the sense that how would you police that? It'd be very, very difficult. Okay, now that did, however, set up the Obergefell case that we're going to look at here in a second. We're going to look at Loving versus Virginia, but we're going to talk about marriage rights. Now, admittedly, when it comes to marriage rights, this is I could have put this in this section in civil liberties, or I could have put it in civil rights. We're going to talk actually about these two cases in both places. We're going to spend more time here, the Obergefell case, a little bit more here. Okay, now Loving versus Virginia is really kind of our starting point. There have actually been two movies that have been made based on this case. They're both actually quite good. But this is a case whereby the Supreme Court said, you know what, the right to privacy covers marital rights. Okay? And in doing so, found unconstitutional a state law prohibiting marriage between people of different races. Now, again, in 2018, it almost seems unfathomable, right? So this case is actually a year older than I am. You just can't imagine. It's like, my gosh, of course that would be a violation of somebody's civil rights or civil liberties. Again, we're putting in the civil liberties chapter, admittedly, whereby two people that love each other, they just happen to be of different races that they couldn't marry. I mean, it's almost unfathomable to us. But again, it was a controversial issue at the time. Society has certainly changed, and we really couldn't imagine it going other way. But many states really did have these. Now, admittedly, Virginia was one of the last ones, but they did actually prohibit marriage between those of two different races. Now, you can imagine some of the other satellite issues you would get into, something like that. How do you know somebody's Caucasian, and how do you know somebody's African American, and what percentage you have to be of which? I mean, it's really, really quite crazy. Okay, so with that said, let's look at the Obergefell case that was decided just 3 years ago. Now, essentially what the Supreme Court said, again, it's fundamental root. The United States Supreme Court said that no state can prohibit same-sex marriage, right? Now, so in all 50 states, right, states must recognize and must allow two people of the same gender to marry. Okay, now, much akin to what we were looking at in regard to actually the Loving case as well as the abortion case. These were state laws. Okay, now the Gonzalez case, when we were looking at the federal ban, admittedly was a little bit of an offshoot. Okay, but again, we're looking at state law here. Okay, we're looking at state law. So many states actually prior to that, right, certainly less than a majority, but many states had actually done this on their own, saying, yeah, you know what, why would we prohibit that? Okay. And the 2004 presidential election, which had other elections, there were Senate races and House races and things like that. This was a pivotal year, I think, and I think most political scientists would agree, whereby society kind of thought, okay, now we've gone too far. So what does that mean? Well, there were many statewide ballot issues that were designed to prohibit same-sex marriage. Okay? Because many people thought that, well, states were doing it on their own, but maybe, hey, not in my state, right? Okay? And Ohio was one of these states that actually went through this. But again, many states had those on the ballot box in 2004, either through referendum or initiative process, one of the two. Okay, but nonetheless, kind of a powerful issue. Now, backing up a little bit, did Lawrence versus Texas, the 2003 decision, have something to do with that? Maybe. Did the fact that a lot of states had been legalizing same-sex marriage on their own do something? A little bit, okay? But it's interesting, you know, again, marriage is seen as one of those private rights, and that's how the Supreme Court, again, has extended the right to privacy to marriage rights. Now, actually, there have been some other case. There's been one other case. There's a Blocky versus Red Hale case in 1978. You don't really need to know it. But it was the only time, really, that the Supreme Court got into marital rights and saw marriage as really a fundamental right. And since there was, I believe it was a Wisconsin law that had prohibited somebody from getting married if they had an outstanding child support debt. I mean, you could kind of see both sides of this. Like, we're not going to let you get married if you've got an outstanding child support obligation, because we're afraid you're going to get married and have more kids and not take care of those either. But nonetheless, again, you don't have to marry to have kids either. So it was just kind of one of those odd issues, and I don't think there were really a whole lot of politics involved in the Wisconsin, I believe it was Wisconsin law. But anyway, you kind of get the idea. But marriage, again, what I want you to see here is one of those rights covered pursuant to the right to privacy. Okay, all right, so again, state by state by state by state. Now, to finish off marriage, can states still, all right, have their own marriage laws? Absolutely, all right? But what you get from Loving and what you get from the Obergefell case is the sense that you can't treat people differently based on race, and you can't treat them differently based on their gender, okay? Can you treat people differently based on age? Sure, right? Can you prohibit first cousins from marrying? Sure, okay? You just can't treat people differently based on race or gender. Okay, now criminal justice, just one last case here for this section. Now, if this were a full-blown criminal procedure case, what I could tell you is that we'd spend a lot of time talking about how the Fourth Amendment itself is really a privacy right. So if I have protection against unlawful search and seizure, right, we had mentioned last week, that's a privacy right to me, that you can't just come into my house, police officer, without a warrant and check my house, right? Or again, if you remember with automobile searches, you can't just go search my car unless I give you consent, all right? Or you have probable cause, okay? Kind of a privacy right. Now, this was an issue, the Jones case, 2012, was about 6 years old, 2012, where the question became, could law enforcement attach a unnoticeable, clearly in today's era of technology, an unnoticeable GPS device on a suspected drug dealer, just to follow this person all the way or wherever they go, all right? Now, again, if we had more time, we had more in the way of Fourth Amendment room, I guess, if you will, we would spend some time looking at some cases where you could see that maybe there really was a precedent to allow that, all right? And there were a few cases where, again, even somebody who had not been indicted could actually be followed around through some type of electronic means, okay? But the Supreme Court, interestingly enough, went the other way and found that law enforcement officers would violate the right to privacy as well as Fourth Amendment rights, right? Kind of working together. So you see a marriage of those two rights, the right to privacy and the Fourth Amendment, which makes sense because, again, according to Justice Douglas, as we had mentioned in the Griswold case, the Fourth Amendment was part of that, okay? But again, finding that law enforcement officers cannot simply just attach a GPS device and follow a suspected drug dealer, okay? Okay, so what we're going to do is we're going to go ahead and stop there, all right? And what we'll do, since I think that's a pretty good chunk of time, is we'll stop there and we'll move into chapter 5, and again, this is going to be the outline number 9 on equal rights, and go from there. All right, see you Monday.